Qualifying for Medicaid without losing everything you have is possible. How do you qualify for Medicaid without losing everything you have in the process? Hi, I'm Gary DeWitt, the founder of DeWitt Law, and that's just what I'm going to tell you now. I have good news and bad news. You usually can't protect everything you have, but you can protect a lot of what you have. Qualifying for Medicaid requires one of two things to make it all work. First, the person needing long-term care must be mentally competent and able to sign the forms and move money around. Or second, the spouse or family must have a durable power of attorney with enough power and language to let them sign the forms and move money around. If you don't have a power of attorney or haven't had it reviewed for Medicaid purposes, I highly recommend getting it done before you need to apply for long-term care. Medicaid was created in 1965 to assist low-income people get long-term care. Medicaid provides health care coverage to millions of Americans, including eligible low-income adults, children, pregnant women, elderly adults, and people with disabilities. Medicaid is administered by the states according to federal requirements. The program is funded jointly by states and the federal government. Qualifying for Medicaid has income and asset limits. For Medicaid purposes, you have two kinds of assets. First, you have countable assets. These are assets Medicaid is going to count against you. You also have non-countable assets, which I'll talk about. First, everybody is allowed to have a home under Medicaid law. The equity in that house can be up to $603,000 in 2021. Thanks to some changes that happened in August of 2021, this equity can be preserved for the family in Arkansas. Let me clarify that. Everybody is allowed to have a home and all adjoining real estate if it's worth less than $603,000. And adjoining means across the road too. But it doesn't mean that you can have property in another state or another area of the state. That property would count. Second, a couple is allowed to keep up to $130,380 of cash on hand. I'll come back to this in a minute because it's not quite that simple. The individual needing care can make up to $2,382 per month of gross income. The person that stays at home is allowed unlimited income. The individual needing care can have $2,000 in their name. An unmarried individual can have a home too, but they can only have $2,000 in their name. Let's talk about the cash on hand limits. I said earlier that a couple, the spouse staying at home, can have $130,380 of cash or cash equivalents. In Arkansas, that includes checking, savings, 401ks, IRAs, stocks, bonds, investments accounts, and more. This doesn't mean you have to spend all your excess on nursing home care. You can turn countable assets, cash, into non-countable assets. You can spend money to improve your home, pay down the mortgage, buy a new car, prepay a funeral, and much more. You can also turn cash on hand into an income stream. This is done with special financial planning. The reason we talk so much about what you can spend money on and how much you can have is that Arkansas is a half state. That means that a couple can keep half their cash on hand up to the $130,380 limit. For example, if you have $200,000, you can keep $100,000. If you have $260,760 or more, you keep $130,380. Qualifying one person in a couple usually consists of coming up with a good spending plan and converting excess cash into income for the spouse staying at home. We arrange the accounts so the person at home's name is on the accounts. We open an account for the person that needs care in just their name and put $2,000 in it. If the person needing care makes over $2,382 per month, then a special trust must be set up to hold the excess. In the end, the money in that trust gets paid over to Medicaid. Qualifying a single person for Medicaid is harder than qualifying a person in a couple. First, a single individual can only have a total of $2,000 on hand. Their income is limited to $2,382 a month. So what to do if mom or dad has $100,000 in retirement account? Before I explain how to handle this, I need to go over the penalty period. If somebody gives away property within 5 years of applying for Medicaid, and then that gift is penalized by the Medicaid rules. Technically, the gift has to be made for the purpose of qualifying for Medicaid to be penalized. The penalty is that the person must pay for their own care for a period of time until the penalty is used up. So, if Mom gave away $25,000 last year knowing she would need help, and the penalty is $5,000 per month, then Mom must pay for 5 months of care. Medicaid has a penalty period for giving money away. But what if we do it anyway, in a controlled fashion? Can we give some money to the family but pay for care during the penalty period? I'm going to use $5,000 as the monthly penalty for easy math, but in reality it is $5,871 per month in Arkansas. Assume Dad has $102,000 in the bank. He gets to keep $2,000, leaving $100,000 that must be dealt with before he can qualify. What if he gave half to the family and turned the other half into income payable to the nursing home? So $50,000 goes to the family. This is going to result in a 10-month penalty period. That is, $50,000 divided by $5,000 per month. But Dad kept $50,000. That's more than the $2,000 he's allowed, so we take Dad's money and turn it into a stream of income paid to the nursing home for 10 months at $5,000 a month. It's not nearly as simple as that, because income and other things must be factored into the calculations. I highly recommend seeking professional legal help that knows how to do the calculations. Qualifying for Medicaid for a couple is about the same as qualifying an individual. The only real difference is the couple can have $3,000 of cash. Qualifying for Medicaid starts now. You need to get comprehensive, complete, durable powers of attorney done so that your family doesn't have to worry about it later. You see, if you need long-term care and can't make the decisions, you can't sign a power of attorney and it's too late to protect what you have. You need to meet with an experienced estate planning and elder law attorney that knows what can be done now to get as many assets protected as possible for the ravaging cost of long-term care. They will guide you in what can be done to protect your assets.